seems interesting in light of the fact that post-COVID, the traditional notions of dispute resolution have come to be challenged. What happened was in times of COVID, entire system was to be rejected. And then the courts found it more feasible, more accessible, that technology should be integrated into the court-based system. So the concept of ODR is not, very new to the Indian jurisdiction. In fact, many jurisdictions across the world have been, using ODR for resolution of disputes. COVID can be seen to be, a step. COVID-19, maybe, it was a, blessing in disguise for this form of dispute resolution, because the system got to know that you can use ODR for containment of disputes. So what is ODR? It is important to understand what is ODR. ODR basically stands for EADR, that is, use of technology with ADR. Recently, Niti Aayog has also done a study on ODR under the chairmanship of Justice A.K. Sikri to find out what are the benefits of ODR. Now, as I see ODR has many benefits. The first is it cut down the cost for the litigants. And when the cost comes down, for every litigant, it's an encouragement. So what happens is, otherwise, for a person who wants to do litigation, he has to go to court and appear before court. And, he has to be personally present for everything. The pleadings have to be in a physical format. The evidence has to be there. The person has to be there to depose. So when it comes to ODR, what happens is you can do your pleadings in electronic form. The person who has to adjudicate can be in any part of the world, and he can just sit across the screen and, resolve the disputes. Your evidence can be done through electronic mode. Everything can be done through electronic mode. So there are many benefits which this system brings to the table. Now, it is important to understand that whether do we have any in India, do we have any legislations, who can help this stream grow? As I understand, that we have to look at both kind of legislations. One with respect to the law itself, which talks about inclusion of ADR, and the other would be the legislations which talk about technology or integration of technology. Now, when it comes to, legislations which majorly talk about ADR, the first and foremost which comes to everyone's mind is Arbitration and Conciliation Act 1996, which actually talks about how to resolve disputes through arbitration and conciliation. That act has been amended in 2015, in 2019, and recently in 2021, so that, India can be made a hub of arbitration. The second legislation, which of course, is a predecessor, that is called the Code of Civil Procedure, which came in 1908. And Section 89 of that code gives court the power to, subject to the convenience of the parties, to ask the parties to go for mediation or conciliation, or maybe in two lok adalats. So, except the ADR, except the Arbitration Act, which is the seminal legislation, you have CPC, which also gives power to, ask parties to go for these kind of settlements. The other legislations, maybe the Family Code Act, or, maybe the Companies Act or the Consumer Protection Act, or the Industrial Code as well. These legislations also, provide parties state, and they have provisions which state that the parties should go for mediations or arbitration. So, at one stage, you have legislations which talk about inclusion of ADR and how ADR can be performed. At the other side, there are legislations which all talk about how you can integrate technology with ADR. And these legislations are, the Evidence Act for our reason. Section 65B, which is the seminal section in this case, talks about how secondary evidence could be given in case of, if you are submitting electronic evidence, how that is to be considered as a secondary evidence. So when you talk about this stream of dispute resolution, which is called ODR, what you have to see is that we are on one side you have legislations which talk about ADR, how to include ADR. On one side you have legislations which support integration of technology with ADR. Evidence Act is one. The other act would be, Information Technology Act, which says that, if you can, electronic documents can be considered, signatures on documents or electronic signatures can be considered valid. So you have Information Technology Act, which also substantiate or supplements the legislations which actually talk about ADR. So when you look at India, you have legislation in place which talk about integration of technology with ADR. However, there are certain legislations which are which we have to see that they are still in pipeline. Like there was a mediation bill which was tabled, which is still in the draft stage, which talks about how we can include mediation as one of the process of dispute resolution. Privacy has been one of the concerns because when we are talking about ODR, where two parties sit across, in different parts of the world, sit across their computer screen to resolve a dispute, privacy would be one of the concerns. So these two legislations are the legislations which one has to look at, maybe which are going to also change the future of ODR in India when we talk about ODR. However, that being said, that definitely technology is a boon, and ODR would be the future. I don't have to put it in some other words, but I understand ODR will be the future because you have to integrate technology. Otherwise, there's no means left for you. And it is good to be, it's good when technology is integrated in this process, because for litigants it cut costs, for lawyers it cut costs, for judges or neutrals who educate over dispute it cut costs. And it's all about, when you go to litigation, it is all about how you save your money. So it is important to understand that ODR is just not the need of the hour, it is a future from which we cannot take a detour.